Hi, my name is Neal Datta and I'm an immigration attorney here in New York City. Today I'm going to give a little bit of information about a process called a provisional waiver. If you entered the United States with a visa, right, then you have one route that you can take under the law in order to ultimately get your lawful status. And that generally is called adjustment of status. On the other hand, if you entered the United States in some other manner, for example, by crossing the border without inspection, then even though you're married to a citizen, or even though your parent is a citizen, you're not going to be able to finally process your immigration papers here in the United States. Instead, you're going to have to hop on an airplane and go back to the consulate, the American consulate in your country, in order to finalize your status. So what happened is that in March of 2013, the administration instituted a change to the waiver process. And that is that they created a system whereby a person could apply for a provisional waiver. The provision would be that you depart after the waiver is approved, and the key change was simply when you had to apply for the waiver. So whereas before you had to leave the United States and apply for your waiver at the consulate, now you can file for your waiver before your departure and then wait in the United States until you receive a decision on your application. And if your application for a waiver is approved, then what happens is you then get on an airplane, go to the American Embassy for your appointment, and then, generally speaking, if there are no other problems, your immigrant visa will be issued and you'll be able to return to the United States. In the next video, we'll talk a little bit about how to prove that you're eligible for the waiver. The first thing that will happen is your relative, your U.S. citizen relative, will file an immigrant visa petition, Form I-130, on your behalf with the United States Citizenship and Immigration Service. And you send that in with proof that they're a citizen, with proof that they're your family member, whether that be a birth certificate or a marriage certificate. And then you wait. And generally it's taking about 7 months now for those petitions to be approved. Now after it's approved, the petition is then forwarded to another agency, which is called the National Visa Center. The National Visa Center will then send you a bill, and they'll say, hey, please pay this money so we can continue processing your immigrant visa. At the point of your paying for your immigrant visa, you then will file another application, which is called an I-601A application for Provisional Waiver of Inadmissibility. That form will be filed with USCIS here in the United States. Now, when you file that petition, you have to be able to show that without you, the alien, in the United States, your U.S. citizen relative will suffer an extreme hardship without you. And that's the difficult part about a 601 waiver. That is, proving that your spouse or parent or child, whoever is petitioning for you, will suffer an extreme hardship without you. Now, assuming you can do that, then the service, United States Citizenship and Immigration Service, will approve or deny your petition, your application for a waiver. If they approve it, then they notify the National Visa Center. The National Visa Center will then continue processing your immigrant visa, asking you for some more documents. You will then send those, and then eventually the National Visa Center will forward your entire immigrant visa application to the American consulate. The American consulate will then schedule an interview. And it's at that point in time that your family member will have to jump on an airplane, generally about 2 weeks before the interview, and depart. Now, upon arrival in their country, they'll go and get fingerprinted, they'll go and have a blood test, and then they will go attend their interview. Now, at the moment of their interview, they're going to have an approved provisional waiver. And that waiver waives the 10-year bar, which was accrued as a result of their having been in the United States for more than 1 year illegally. Now, upon presenting that, that will no longer be a basis for them to refuse issuing an immigrant visa on that grounds. And presumably, if there are no other bases upon which they could refuse an immigrant visa, like a criminal history or a prior deportation or some earlier attempt to obtain an immigration benefit through fraud, then they should issue you an immigrant visa, at which point you would be able to get on an airplane, return to the United States, and be granted your lawful permanent residency. This is a program that has been very beneficial. There are a number of people who've been able to successfully navigate this process, process their visas, come back to the United States, and resume lives with their families as lawful permanent residents. Now, the crux of this case is proving that your spouse or parent or child will suffer an extreme hardship. And that's something that is a complex issue, and it's something that I will address and try to clarify in another video. Thank you. If you have any questions about how to handle this type of process, of course, that is within my expertise. That's the kind of cases we like to do. We like to help families resolve their immigration status so they can live together in the United States. Thank you for listening, and feel free to call us or send us an email with any of your questions. Thank you.